Most people that come and sit across the table from one of our lawyers here at Kampen Law are curious to know what their case is worth. And that is usually determined based on two factors. And if you want to think of it as a graph, on the one axis is likelihood of success on the merits. So how likely are you to win your lawsuit? And then on the other axis is if you win, what are you likely to receive from a judge or a jury in the way of damages. And so in this video, I'm going to teach you about the different categories of damages that you can recover in an employment lawsuit. So the most common damage is called back pay or back pay and benefits. So obviously when you're fired, you have a loss of income. And what would you have earned if you continued to work at the company? And so for back pay, what we're looking at is how much have you lost since the date you were fired until the judge or the jury issues you an award. And so that would be essentially whatever your salary and benefits would have been through that date. However, you have a duty to what's called mitigate your damages. And so you can't just stay at home, put your feet up, and take up soap operas. The law expects you to look for a job. And it's really important for people who are bringing employment cases to make sure that you document that job search methodically. Because the company attorneys are always going to try to say that you didn't look for a job very hard. And so if you keep a chart of all the places that you applied and your interviews, you can show that you were in fact diligent with that job search. But understand, when you get that new job, unfortunately, the employer gets a dollar for dollar credit for anything that you earned, comes off of your back pay. But again, the law requires you to look for that job. Now, in addition to back pay and benefits, you can also get what are called front pay and benefits. And so that is essentially looking forward. What are your future lost wages and benefits? And that's usually the judge's determination. Sometimes people get excited and say, well, I would have worked through retirement 20 years from now. Can I get front pay for 20 years? And the reality is, no, judges aren't going to give you 20 years of front pay in most cases. But 5 years is not an unusual amount of front pay. But here again, the employer is still going to get a credit for what you would have earned in those 5-year period as well. In addition to those kind of economic damages, you can also recover pain and suffering and emotional distress damages. Now here, it's important to understand that the employer is on the hook for the emotional distress that has been caused by your termination. They're not on the hook for emotional distress that you've suffered from other causes that are going on in your life. But understand, you're not required to, arrive in the courthouse a perfectly healthy person. Lots of us suffer from depression or anxiety long before something bad happens to you at work. But the good news is, even if you've had some other pre-existing conditions before, if those conditions have gotten worse as a result of harassment or termination, the employer can still be on the hook for that exacerbation of those previous conditions. In addition to that category of damage, you can recover what are called consequential damages. So sometimes we have to liquidate our 401k plan, for example, or we may have to sell a prized possession at a discount. Where you are incurring penalties or interest because you go into debt, for example, you can recover that interest and penalty in your lawsuit as well. And then finally, there's a category of damages called punitive damages. And this category of damages are designed essentially to punish the employer or deter the employer because they've engaged in some sort of malicious conduct. And it's not uncommon for juries to want to award punitive damages, but you can't assume that you're going to get those. It depends really on the severity of the discrimination in your case. And then finally, the good news is Congress and the laws that apply here have recognized that that attorneys need to be incentivized to take cases, even for people whose wages may be really low. And so in a scenario where we may represent an employee who worked, for example, at a McDonald's, they may only have $30,000 in lost wages, but the law will require McDonald's to pay the attorney's fees and costs for that worker if they win. And so that is called a fee shifting provision. And so a lot of times, even if employers aren't worried about getting hit with a big award for lost wages, that attorney fee shifting provision can be a deterrent for employers to discriminate against hourly workers. And so while bringing these kind of cases is not something to do lightly, you do it if you need to. But if you have to file a lawsuit, there are all kinds of damages that you can recover from employers if you win.